Good morning. My name is Alicia, and I would like to welcome you to OSC's Public Contracting Oversight Division Introduction Webinar for new officers, employees, and appointees of New Jersey's local units, boards of education, county colleges, and other public educational units. Our agenda for today's webinar is as follows. We will begin by introducing you to the Office of the State Comptroller. We will then explain what the Public Contracting Oversight Division of OSC does as it relates to the governmental units you represent. Then we will spend some time explaining PCO's procurement review processes, including an explanation of what constitutes a contract and a procurement, and what specific things we are looking for when we do a review. We will then briefly discuss some high-level compliance matters that will be very useful to you as you start in your new positions. And finally, we will take questions. Please note this presentation will be made available to all of those who are registered for this session at the conclusion of the webinar, with active links for all of the links you will see throughout the presentation. We hope this will assist you in not only gaining a high-level understanding of procurement and contracting in New Jersey government, but also provide you with a practical guidance document you can use to find other information you may need as you begin your work. So let's talk a little bit about OSC. OSC was established by law in 2007, and the office was created in 2008. The mission and statutory obligations of OSC are to monitor, investigate, and review all units of New Jersey government, which means all state and local governmental units in New Jersey constituting around 1,900 separate entities. This includes independent state authorities and commissions, state agencies and offices, local units and all of their authorities, utilities, and commissions, counties and all of their authorities, utilities, and commissions, school districts and school boards, whether operating or not, and all units of public education, including all units of higher education. OSC has the statutory authority to provide guidance, technical assistance, performance reviews, procurement reviews, and training regarding best practices, legal compliance, and procedures to eliminate fraud, waste, and abuse. OSC has 4 divisions: Medicaid fraud, which is the successor of what was once known as New Jersey Medicaid Inspector General, and then the Audit Division, the Investigations Division, and the Public Contracting Oversight Divisions, which used to be known as the Procurement Division. Today, we will specifically introduce you to the Public Contracting Oversight Division, which was formerly known as the Procurement Division, and which we sometimes refer to as PCO. PCO monitors, reviews, and provides technical guidance and technical assistance relating to public contracting to all of New Jersey's governmental units. PCO's duty is to ensure compliance with all applicable laws relating to the procurement processes and contracts it reviews. New Jersey laws were enacted to ensure competition, transparency, and public confidence in government spending. Compliance with these laws is imperative to demonstrate the level of competition, transparency, fairness, and equality in public spending in New Jersey that is required to maintain public confidence in our government. PCO has the authority to investigate procurement and contract-related matters and to issue public and private letters and reports based upon our findings stemming from our monitoring, investigating, and reviews. But any public issuance is subject to specific regulations regarding notice. Generally, absent a public issuance, documents reviewed by the Public Contracting Oversight Division are subject to statutory confidentiality requirements and are subject to the advisory, consultative, and deliberative process exemption under OPRA. I think it's important for you to know who we are and who you and your teams will be interacting with when submitting procurements and contracts to us. My name is Alicia Walsh. I'm the director. I've been with OSC for about 10 years. Jeff is our acting deputy. He has been with OSC for almost 5 years. Ashley is our acting supervising attorney, and she's been with OSC for about 4 years. And we also have 9 staff and senior staff attorneys, 1 paralegal, and 1 administrator within our division. Collectively, our division has over half a century of experience in government and over a quarter-century experience in procurement law. Now I'll turn it over to Jeff for a more in-depth understanding of specifically what your interactions with OSC will look like.
Thank you,
Thank you,
Alicia.
Alicia.
So I am going to take you through the PCO review process. As a starting point, PCO gets its authority to review procurements from our enabling statute, which is found at N.J.S.A 5215C-1 et sec. Procurement reviews specifically, what we're going to talk about today, are discussed at N.J.S.A 5215C-10. When I talk about procurement, I'm referring to the whole process that a public entity goes through to issue a contract. In many cases, this will include an initial advertisement to potential vendors and a request for bids or proposals, what we refer to as a solicitation, and then a contract award process. In other cases, a procurement may include different steps, depending, as we will discuss a bit later, on what procurement laws apply. PCO reviews the procurement procedures that a contracting unit intends to follow, or in some cases, already followed, when issuing a contract for compliance with applicable law. OSC's procurement review process begins when a contracting unit provides us with notice that it plans to conduct a procurement that will have a cost in excess of certain thresholds established in our statute. Contracting units provide that notice by submitting the appropriate form on our website, which we'll have a link to on the next slide. PCO has a handful of different thresholds that trigger notice to OSC, which we will talk about more on the next few slides. When specifically you have to provide notice to PCO of a particular procurement depends on what threshold the procurement falls under. Here's the link to our website. When you go to that website, you will see all of our forms for providing notice to OSC, along with a description of what type of procurement each form should be used for. Our website also has instructions for submitting the forms to us. These forms have to be submitted in a very specific way to work with our software, so please follow those instructions closely. Along with the notice form itself, contracting units have to provide PCO with documents that it intends to use in its procurement process, including its proposed solicitation and contract documents. PCO's regulations, which are found at N.J.A.C 1970-3.1, the citation that's listed here, will walk you through every step of the submission process, including a more specific breakdown of the particular documents that have to be submitted to PCO. So I'd highly encourage you all to read those regulations before submitting to us. So as I said earlier, we have different thresholds that apply to different types of procurements, and those are listed here. So our first threshold, well, before talking about our thresholds, these numbers that you'll see here, these number thresholds are a bit are significantly higher than what they used to be. When our statute was first enacted in 2007, our thresholds were lower. However, our statute also requires our thresholds to be adjusted for inflation every 5 years. That adjustment just occurred again this fiscal year. So these are our current thresholds for this fiscal year. Contracts greater than 15.2 million are required to be submitted at least 30 days before advertisement or solicitation. When you submit these contracts to us, we will work cooperatively with you as the contracting unit in order to resolve any issues or concerns that we find. Contracts greater than 3 million but less than 15.2 million need to be submitted no later than 20 business days after award. So these ones are retroactive reviews. And emergency contracts greater than $3 million, those are contracts that are awarded to an emergency or exigency process recognized under law, need to be submitted no later than 30 business days after award. PCO statute and regulations define what types of contracts have to be submitted to us for procurement reviews if they exceed our thresholds. I want to highlight that when our statute talks about the contracts that have to be submitted to us, our statute uses the term contract in a very specific way that may differ from how you see the term used elsewhere in the law. Our regulations define the term contract as an agreement supported by consideration and enforceable at law, and any amendments, extensions, modifications, or change orders thereto. Amendments, extensions, and modifications and change orders are considered contracts in and of themselves for the purposes of our statute, and to the extent that they meet our threshold, have to be submitted to us for procurement review. When it comes to determining whether a contract value meets our thresholds, our regulations lay out the process for assessing different types of situations, like contracts that span multiple years, contracts with optional extensions, or procurements where more than one contract will be awarded through a single procurement process. We also recognize that in some cases, it may not be totally straightforward what the value of a contract will be. In those cases, contracting units are to act in good faith to ascertain an estimated value of the contract. The expectation here is that the contracting unit will use good professional judgment to come up with this estimated value. If the contracting unit has procured similar goods, services, or construction work previously, the value of that similar procurement should be taken into account when formulating your estimate. It is also important to note that some types of agreements are not considered contracts that need to be submitted to us and that we don't review. Some examples are collective bargaining agreements and employment agreements. We also don't review redevelopment agreements, though we may review contracts for work to be conducted in a redevelopment area or pursuant to a redevelopment plan. So what are we actually looking for when we review procurements? Broadly speaking, we review procurements to ensure that they have the requisite level of open competition, fairness, and transparency required by law. The actual procedures by which we conduct our procurement reviews and provide written guidance regarding any issues that we see is described at N.J.A.C. 1970-3.11, which is cited here, and which I would encourage you all to read. Drilling down more specifically into some of the things that we commonly look for, those include, for example, whether the contracting unit's solicitation documents use the correct statute. Different contracting units are subject to different procurement statutes. Those procurement statutes describe the process and requirements that apply when the contracting unit conducts a procurement. In some cases, like with local land and buildings law, the appropriate procurement statute may be determined by the type of procurement that is being carried out or the type of contract that is anticipated as well. In some cases, a specific statute will lay out different procurement procedures that apply in different situations, depending on what the contracting unit wants to procure or how it intends to procure it. So we'll look at whether the contracting unit is following a procurement procedure allowed for that particular procurement by the applicable statute. For contracting documents submitted after award, we'll also look at the award process that the contracting unit followed. Some of the things that we'll look for in the award process are, did the entity follow proper procedures for awarding the contract under the statute that applies? Was the contract awarded pursuant to the proper standard? For example, some contracts have to be awarded to the lowest bidder, while others have to be awarded based on other criteria. Was the contract awarded for the correct duration? Did the bidder proposal comply with the process described in the contracting unit solicitation documents? Were the required forms properly completed by the awarded vendor? And if there was a bid protest or litigation that was contested, was what was contested and was it justified? Or in other words, is there something that the contracting unit could have potentially done different to avoid a protest or litigation? One thing we always look for really closely when we conduct procurement reviews is whether the procurement includes the correct compliance forms. Various statutes require a lot of different forms to be submitted by potential vendors at different stages of the procurement process. In some cases, certain forms may be required from potential vendors at the time that they bid on a contract. And here are some illustrative examples of forms that are typically required at the time of bidding under local public contracts law specifically. Other forms may be required from potential vendors after bids are submitted, but before a contract is awarded. Here again are some illustrative examples from local public contracts law. I do want to note that the exact forms that are required may vary depending on what is being procured and what procurement statute applies. Please ensure that you check the exact requirements that apply to your particular contract type when putting together your solicitation documents. I do want to highlight that this table and other useful resources are available at the website that we have provided here. Besides OSC's website, there are a handful of other resources that you should be aware of. The first is the website for the Division of Local Government Services, which we often abbreviate to DLGS. DLGS is part of the Department of Community Affairs, and they are responsible for overseeing the regulations that govern procurements by municipalities and school districts, among other things. DLGS has model procurement forms and various other resources on its website, which I have linked to. They also publish something called local finance notices, which we call LFNs, that provide additional guidance on many aspects of the procurement process. So if you're looking for information about how to conduct some aspect of the procurement process that isn't clear from the statute or regulations alone, that's often a good place to start. Besides DLGS, the Department of Labor and Workforce Development, DLW, has a really helpful website that describes the prevailing wage requirements that apply to public works contracts. DLW also has a website that lists the vendors and contractors that are disbarred from public contracting due to various labor violations, which is something you may need to refer to during the procurement process. Thank you all very much for taking the time to attend this webinar. Here is our contact information should you need to reach us, as well as our website and the specific page for submitting contracts to us. Then thank you all very much for your time, and I appreciate you attending this webinar.